We'll save him to the end. And I don't know why I've been blessed with such a small calendar today,
I
but
saw,
I'm not
I
going
saw,
to look a gift horse in the mouth. I'm going to be appreciative of it.
I saw the same thing. I was like, this it? I was like, oh man, this is very good.
So, all right. Um, we have no Spanish speakers, correct?
No, Your Honor. No,
Okay.
sir.
And okay, so we can get started. And I'm just going to make a brief statement that if anybody's hired a lawyer, I don't want to interfere with that process. So if someone has hired a lawyer, we'll wait for that person.
Oh, staff notes. Hey, it was sure.
Could we turn the camera on the men's side?
Hey, Your Honor.
Okay. Looks like it's frozen. Okay.
Okay, here we go.
All right. So we're starting early today. Normally we would start at 11 o'clock. And so if anyone has hired a lawyer to represent them here today, let me know and we'll hold you and wait for your lawyer to appear. So this is your first appearance hearing before the Magistrate Court of Clayton County. My name is Brad Gardner, and I'm a judge in this court. I'm not here to conduct a trial of your case or to take a plea in your case. I am here to inform you of the charges that have been filed against you, to advise you of certain rights, to set bail on those offenses that I'm authorized to set bail, to schedule a preliminary hearing, and to determine whether you require the assistance of an attorney. You have the right to remain silent and say nothing, but should you give up this right, anything you say during this proceeding may be used against you if your case goes to trial. So please don't discuss the facts of your case. During this and all other proceedings, you have the following rights: the right to the presumption of innocence, the right to indictment by a grand jury for most felonies or by accusation for misdemeanors, the right to a speedy and public trial by jury, the right to see, hear, and question witnesses who are called to testify against you, the right to compel the attendance of witnesses to testify on your behalf, the right to testify on your own behalf or offer evidence in your own defense, the right to have an attorney represent you. If you cannot afford an attorney, one can be appointed to represent you if you qualify. Some of you will be allowed to post unrestricted bonds for your release from jail. These bonds may be posted by cash, commercial, or property. If you post a cash bond, someone will deliver the full amount of the bond and fees in cash to the sheriff's office. The sheriff's office will hold the cash and return it at the end of the case. If you use a commercial bonding company, someone would have to pay a fee to the company for their service. The fee will not be returned. I don't know what fee will be charged, but it is usually based on a percentage of the bond. Finally, if you use property to post a bond, the property will need to have a net equity at least 3 times the total amount of the bond. Some of you will have special conditions on your bond that prohibit you from contacting certain people or going to certain places. This special condition will be provided to you on a separate form. You will also be prohibited from contacting the victim while you are in jail. If you violate the court's order, your bond will be revoked and you can remain in jail until your trial. You could also receive additional felony charges. It is important to note that if someone is listed as a victim in your case, that person will not be allowed to post your bond. Some of you are charged with offenses for which this court is not authorized by law to set bail. In this event, a bond hearing will be scheduled before a judge of the Superior Court of Clayton County, and you will be informed of that date. If you are currently on active probation, this court is not authorized to set bond at this time. Whether bond is appropriate in your case will be reconsidered after your probation officer has had an opportunity to consider this new arrest. The purpose of a preliminary hearing is to determine whether there is sufficient evidence to support the allegations against you. The standard at this stage is very low. A judge determining whether a charge goes forward at this stage only has to determine that it is possible that the crime occurred. Everyone has the ability to waive their right to a preliminary hearing. However, you should speak to a lawyer first if you are unsure about whether it is appropriate to waive your preliminary hearing. If you post bond, your preliminary hearing is automatically waived. You will receive notice at the address you give of your next court date. Finally, I need everyone to raise their right hand, please. Do you swear or affirm any statements you make during this proceeding will be the truth, the whole truth, so help you God? Okay. Let's start with the ladies.
Sit down. First, I have Ms. Barlow. Barlow, you can come on up.
Ms. Barlow, you're charged with theft by deception, identity fraud, and computer forgery. There's an indication on your criminal history that you're on probation. That means I cannot set a bond for you at this hearing. I am setting a preliminary hearing date for June 28th and a bond hearing date for July 2nd. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes, sir.
Okay, ma'am, you do qualify for the appointment of a lawyer. I'm going to appoint a lawyer to represent you. Do you have any questions for me?
No, sir.
Okay, ma'am, you're free to go back.
Back to you. Pause a minute. Ms. Lucas.
Ma'am, you've been charged with one count of theft by shoplifting as a misdemeanor. The bond is set at $2,000. Do you believe you can post that bond?
Yes.
You're going to have a preliminary hearing date set for June 29th at 8:30 in the morning. That date will get waived upon your bonding out, and you'll get a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes, sir.
Okay, ma'am, you do qualify. I'm going to appoint a lawyer to represent you. Do you have any questions for me?
No, sir.
Okay, ma'am, you're free to go back.
Thank you.
You're welcome.
I have Ms. Lee.
Miss Lee, ma'am, you're charged with one count of driving under the influence of alcohol to the extent that you're a less than driver. The bond is going to be set at $5,000. Do you believe you can post that bond?
Yes.
You're going to have a preliminary hearing date set for June 29th at 8:30 in the morning. that date will get waived upon your bonding out, and you'll get a new court date in the mail. Do you have any questions? Well, first, let me ask you this question. Do you want me to see if you qualify for the appointment of a lawyer?
Yes.
Okay, you do qualify. I'm going to appoint a lawyer to represent you. Do you have any questions of me, ma'am?
Um, how do I do like a property, there?
So,
I did-
do you own property in Clayton County?
Yes,
So the property would need to have at least a net equity in this situation. Property would need to have at least a net equity of probably $16,000 to $17,000. What happens if you choose to go that route? The sheriff's department will place a lien on that property.
okay,
And when your case is over, they will take the lien off of your property. But you're going to need to be able to produce the deed and the documents to show that you actually own the property and you are a person that can encumber the property, which means you are a person that is in an ownership position that you can sign a document that allows them to put the lien on the property.
okay.
Okay. Any other questions, ma'am?
How exactly do I start that process?
So you're going to have to speak to the clerks, the people in the sheriff's department who are responsible for dealing with that process. They're the ones to speak to.
Okay,
Okay.
all
Any
right.
other questions?
No, thank you, sir.
Okay, ma'am. You're free to go back.
All right.
Your Honor, I have Ms. Perez.
Okay. Ma'am, you've been charged with, it appears to be 7 different offenses related to this traffic stop. Do you want me to give you the bond amount as to each count or just the total bond amount?
The total will be fine, sir.
Okay. So you're going to have a total bond amount of $12,000. Do you believe you can post that bond?
Yes, sir.
Okay. You're going to have a preliminary hearing date that's going to be set for June 29th at 8:30 in the morning. That date will get waived upon your bonding out, and you'll get a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes, sir.
Okay, ma'am, you do qualify. I'm going to appoint a lawyer to represent you. Do you have any questions of me?
No, Your Honor.
Okay, ma'am, you're free to go back.
Thank you.
And hey, Your Honor, Ms. Barlow did have a question for you.
Okay.
Come on, Ms. Barlow.
What's your question, ma'am?
You mentioned that I was on probation.
Yes.
I haven't been on probation.
Okay, give me 1 second. Let me pull it up. Um, it looks like there was a probation revocation proceeding held for you last year. Is that correct?
Last year, no, sir.
Okay. Give me 1 second. I'm scrolling down to it. Um, so what I'm looking at, looks like you've had several probation violations. The last one I'm looking at is from November 23rd of 2020.
I
And
haven't.
out of Jones County.
No, sir, I have not been arrested. I haven't been on any type of probation or anything.
Ma'am, from what I see, you got 14 cycles. And cycles are interactions with law enforcement. So the first one that I'm seeing is, let's see. All right, so the first cycle is from Bibb County in 2016, November 22nd, 2016. You're saying that's not you?
No, sir, that's not me.
Are you saying you've never been arrested?
I've never been arrested. I've never even been to Bibbs County.
Okay. So what I have here is several different names that are being associated with you, and they're not the same.
Is it possible for you to for me to verify my name and date of birth?
Hold on one second. So tell me your true and correct legal name.
My legal name is Mauricia Shante Barlow. Maiden name is Newton.
Okay. Everything that I'm seeing is under the name of Michelle Nicole Barlow.
No, sir.
Or Michelle Nicole Collins. So I'll tell you what I'm going to do, ma'am. I'm going to ask that your identity be verified. I have not had this situation before. And if I can verify your identity, I will reconsider this. So, Deputy, are you there?
Yes, yes, Your Honor.
So, and I know this is probably not on you, and I'll probably ask either Miss Adamson or Miss Burney, but what I'm seeing on the cycle, the GCI that I have, Miss Barlow, her LE number is 2188125.
Yes, sir. That's the one that we have as well.
Okay. I'm gonna ask for verification, and I'll probably call later because I don't know. So, ma'am, my understanding is that this information is verified by fingerprint. And so, just so you understand, I don't just take what you're telling me as being true, but I'm going to look at this and I'm going to verify it because the person that I see as it relates to the criminal history has a lot of theft by deception and other issues. And that sort of fits within this charge that you're being charged with. So I will verify it and make sure that it's clear. And if it's clear, then this decision is going to remain. If it's not clear, then I will and your criminal history shows that you are a person that is eligible for bond, then I'll set bond. But that's all I can tell you right now. So I'll just verify that.
Okay.
Okay?
Yes, sir.
Any other questions?
Uh, I don't have a question, but I would like to mention something to him about the ticket. If that's
I'm
fine.
sorry. You said you don't have any questions, but you would like to do what?
I don't have any questions, but I would like to mention something to you that I received from the detective that was on the case.
Okay, ma'am, you're free to say whatever you want to say.
Okay, so I actually turned myself in. When I spoke with the detective, he had already told me that I did not have a record. This would be a first offender for me. I haven't been locked up and I haven't been on probation or in any type of trouble. So I'm not sure. I'm lost about what's going on with the previous charges because I didn't have anything.
So ma'am, just so you understand, I don't know you, you don't know me. Um, we look at paperwork, we look at what's going on. And it could be an error. It could be an error. And that's why I'm going to double check. But it could be something where you have used 20 different names, 20 different identities, all of that kind of stuff. I don't know. But I am willing to look at this and make sure that we are going down the right path. Okay?
Yes, sir.
Any other questions?
No, sir.
Okay, ma'am, you're free to go back. All
All
right,
right,
let's start on the male side. Thank you, Deputy Durham. Sir, you're Mr. Collins? I'm sorry, sir.
Yes, sir.
Okay, Mr. Collins, you've been charged with one count of improper lane change, one count of following too closely that led to an accident, and one count of driving under the influence of alcohol. I've set a bond of $5,000 on the driving under the influence and $500 for the improper lane change and $500 for the following too closely, which leads to $6,000. Do you believe you can post that bond, sir? You have a preliminary hearing date that's going to be set for June 29th at 8:30 in the morning. That date will get waived upon your bonding out, and you'll get a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
No, sir, you don't have to. No, sir.
Okay, you're going to hire your own lawyer?
Well, that's fine. You can appoint me. You can appoint me one.
Okay. So I'm going to appoint a lawyer to represent you. You are free to fire that lawyer and retain lawyer of your choice. Do you understand that?
Yes, sir.
Okay. Do you have any questions for me, Mr. Collins? Okay, you're free to go back. Mr. Cook is a fugitive from justice, so we're going to do him last. Are you Mr. Cook?
Mr. Harris.
Okay. All right, Mr. Harris. Sir, you're charged with one count of criminal damage to property in the second degree. It's being charged as a felony. You're going to have a $3,000 bond. Do you believe you can post that bond?
Yes, sir.
You're going to have a preliminary hearing date that's going to be set for June 28th at 8:30 in the morning. That date will get waived upon your bonding out, and you'll get a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer? Was that a yes? Okay. Okay, sir, I'm going to find that you qualify. I'm going to appoint a lawyer to represent you. Do you have any questions of me?
No, I don't.
Okay, you're free to go back. Are you Mr. Perry?
Yes, yes, sir. Can I say something before you start?
I mean,
Okay.
when you
Oh,
run,
Mr. Perry, let me get through what I need to get through, and then I'll hear whatever question you have to ask. You're charged with loitering or prowling and obstructing an officer. I've set the bond at $2,000. Do you believe you can post that bond?
no,
Okay.
no,
You're gonna have a preliminary hearing date set for June 29th at 8:30 in the morning. That date will get waived if you're able to bond out. Do you want me to see if you qualify for the appointment of lawyer?
only 115, sir. I mean, and plus, when you run from an officer, that's called flee. I mean, I haven't.
Mr. Perry, do you want me to see if you qualify for the appointment of a lawyer?
Yes,
Okay. How much do you make per hour or per month?
I can make $58,000 in 1 day, sir. I'm God, I promise you. And
Mr. Perry, if you make $28,000 in a month, you don't qualify for an appointed lawyer.
I
Okay.
have,
So you're gonna have to hire a lawyer, or you're gonna have to represent you.
I don't
What?
have, I don't have no, I can't explain it. I don't have no, way to get my money out of my account because somebody stole my money, out of my property. Sir,
Mr. Perry, how much do you earn per hour or per month on an average?
I really been having work this sir. Just honest, being honest, I haven't been working. But I'm telling you what I'm able to do, what I can do.
No, I'm not asking what you can do. I wish that I was 7 feet tall, but I'm 5'7".
Yes, sir.
Okay. So let's talk about reality.
Yes, sir.
How much do you believe you earn either per hour or per month on an average?
Yeah, I'm just supporting him, Lord, please.
So Mr. Perry, if I cannot make this determination, I cannot appoint a lawyer to represent you.
Because I don't have no money. They took all my money from me, sir. They took all my money from me, sir.
So, Mr. Perry, I'm not asking if anybody took your money. I'm asking you on an average from the past, not the present, not the future.
I have no idea, sir.
Okay. So, Mr. Perry, you're going to have to hire your own lawyer, sir.
I don't have no money, sir. I'm just being honest with you. I don't have no money, sir.
So, how is this so difficult? How is this difficult, Mr. Perry? I'm trying to give you a lawyer, and you're making it difficult for me to help you. Is there a reason why, sir?
I've been frustrated, man. Like I'm getting locked up for no reason, man.
So, Mr. Perry, you and I, this is the first time that we've met, correct?
What's up?
And have you been anything but difficult with me? Have you been accommodating to my questions? Have you answered my questions? No, you have not. So let's stop. Let's treat each other as human beings. Okay, can we do that?
You help me out the best way you can.
So, Mr. Perry, I have to write down on a form your money, right? To justify my decision to appoint a lawyer. And if you're not going to give me that information, you don't get a lawyer. So, Mr. Perry, on an average, how much do you make per hour or per month? 0. So you're not working. Okay. So when you said, do you have a job? And you said yes, the answer should have been no. Is that correct?
Yes, sir.
Okay. So you do qualify. I'm going to appoint a lawyer to represent you. Now, Mr. Perry, I'm going to hear Whatever it is, you have to tell me. But keep in mind, I did not arrest you. We're not here to determine whether you're guilty or innocent. Okay? My job is to appoint a lawyer, give you court dates, help you to defend yourself. Do you understand that? So what is it that you want to tell me?
Okay. I mean, when you run from officer, I mean, that's called flee, right?
I'm sorry?
When you run from an officer, that's called fleeing from an officer, right?
No.
Okay. I mean, long as you in my position, I should be innocent. I mean, in the United States of America. I mean, because let me say as I finish, everybody is under God and he's my witness.
There's a presumption of innocence. A state has to prove you guilty beyond a reasonable doubt.
I mean, I should be innocent only because I am the Lord, George Commander LeBron, and Officer Golden is my witness that I mean, this is my motherland. So if I run for my freedom, I mean, in John chapter 5, the light was shown to the darkness, right? There should be no fight.
Okay, is that all, Mr. Perry? Is that it?
Yes.
Okay, you're free to go back, sir.
Thank you, sir.
Mr. Shelby?
Yes, sir.
Sir, you're charged with 1 count of battery, 1 count of simple assault. You're going to have a total bond that's going to be set at $7,000. Do you believe you can post that bond?
Yes, sir.
There's going to be a stay away provision on this bond to stay away from, looks like Talon Clevenger. Do you understand that? You can have a preliminary hearing date that's going to be set for June 29th at 8:30 in the morning. That date will get waived upon your bonding out, and you'll get a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer? Okay. You do qualify, sir. I'm going to appoint a lawyer to represent you. Do you have any questions of me?
Yes, sir.
Okay, you're free to go back. Is it you're Mr. Thweet? Okay, sir, you've been charged with 1 count of violation of Georgia Controlled Substance Act, 1 count of driving a vehicle with an expired tag, and 1 count of having a vehicle with an altered tag. I've set a total bond of $3,000. Do you believe you can post that bond? Okay, the VGCSA charge is a felony charge, so you're going to have a preliminary hearing date that's going to be set for June 28th at 8:30 in the morning. That date will get waived upon your bonding out, and you'll get a new court date in the mail. Do you want me to see if you qualify for the appointment of a lawyer? Okay. Okay, sir, you do qualify. I'm going to appoint a lawyer to represent you. Do you have any questions for me?
I just heard about the alarm on.
I'm sorry, say that again.
I can get a alarm bond, sir.
A lower bond. Okay, so for the cocaine, let's see. So for the cocaine charge, I've set a bond of $2,000. For the 2 tag charges, the bonds are set at $500 a piece. I don't think I can go much lower than that.
Man, I just don't have much family. So like, I own my own business, you know, but it's nonprofit. And I'm a reverend, and also like, you know, my home, like, I own car.
I understand, and so the bond is not set to punish you. The cocaine, do you go to, let's assume that you actually got the cocaine. Do you go to the cocaine dealer and say, I want you to lower the price for the cocaine? That kind of stuff doesn't happen. So I'm sorry.
He at my brother's house. He got locked up in
Sir, no.
His father's house.
So, well, all I'm saying, Mr. Tweed, is that I'm not going to reduce this. Okay. All right. You're free to go back, sir.
Thank you.
Mr. Towns, sir, you're charged with 1 count of simple assault. I've set the bond at $3,000. Do you believe you can post that bond? There's going to be a stay away provision on the bond to stay away from a Zamora Kristen. Do you understand that?
Yeah. Yes, sir.
Okay, you're going to have a preliminary hearing date that's going to be set for June 29th at 8:30 in the morning. That date will get waived upon your bonding out, and you'll get a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer? You say yes?
Yes, sir.
Okay. Oh. Let's see. Okay, you do qualify, sir. I'm going to appoint a lawyer to represent you. Do you have any questions for me?
Sir.
Okay, you're free to go back. Okay, are you Mr. Cook? So, Mr. Cook, you're in sort of a different position than the other people. All of the same rights and privileges still apply to you that I discussed earlier, but you're here on what's called a fugitive from justice warrant. And so there's an allegation that you are wanted in Wisconsin for a probation violation. And Clayton County has no interest in that charge or anything else. We're just holding you because we're in an interstate compact that we've all agreed to. So you have a right. Well, first of all, do you have a lawyer representing you on this issue?
No.
Do you have a lawyer representing you up in Wisconsin?
No.
Okay. So what we're here dealing with today, you have a right to demand a hearing to determine, one, whether you are the person that's named in the warrant, and number two, whether the allegation or the charge that they're asking us to hold you on is actually a real charge. So you can demand a hearing, and at that hearing, the judge will make those determinations, whether you are the person named in the warrant, whether you are whether the charges are actually charges that are crimes in Wisconsin. And if the judge makes that determination, the judge will then sign over the writ, and you will get sent back to Wisconsin. So there's a period of time that's up to 60 days. There's an initial 30-day period, and then Wisconsin, if they don't come and get you within the 30-day period, they can request an additional 30 days. If you go through the process of having a hearing, that hearing will be held within 30 days here. And then whenever that hearing is held, if the judge signs the writ, then the 60-day clock begins to run on that day. If you believe that you are the person named in the warrant and that you are on probation in Wisconsin, you can choose to waive that hearing and just say, I want the clock to start today. So if the clock starts today and Wisconsin does not come and get you within the requisite time, the sheriff's office here, they will contact Wisconsin and barring an extraordinary issue, they will release you. Doesn't mean the warrant has been dismissed. You can go, you can leave, run out the front door of the jail, and 5 minutes later, you encounter a police officer in Jonesboro, and that person runs your name, and they see that there is a warrant, and then this whole thing starts all over again. So, do you have any questions about what I just explained to you?
You said like, all right, if I time it to waive it to right now, it's the 60 days start today.
Yes.
So yeah, I'll sign it. Yeah, just
Okay. So you will get presented with the forms. You will sign it, and then they will send those forms over to me, and I'll sign them, and then the clock will begin to run today. Do you have any questions, sir?
no.
Okay. So once you sign the waiver, you'll be free to go back, and then I will sign it, and we'll make sure that this whole process starts today.
So it's 60 days instead of 30, right?
Well, the 30-day period is a statutory period. There can be a request for an additional 30 days, but you have to make a justification for it. It can't be like, just give me another 30 days. It has to be, we had a flood, we had hurricane, we had this, we had that. There's something that interfered with their ability to come and get you within the 30 days.
So basically,
That's
you
the
got,
must.
I understand. Thank you.
Okay. All right. You're free to go back, sir.
I understand.
Hey, Your Honor, they only gave me one seat. Is that okay, or?
So
Yeah, they only gave me one seat.
there have been 7. Normally there are 7 pages.
Yeah.
I'm okay with signing, the number of pages that I get. So last week I signed 1 and I didn't get an issue about it. So
That's you.
yeah, that honestly, once I sign it, I don't know what happens to it. It's like magic. It goes off. So if I need to sign 7, I'll sign 7. If I need to sign 1, I'll sign 1.
Okay.
So, all right.
All right. Yeah, do that.
Okay, you too. Thank